Members, let's resume the special meeting. I now invite Mr. James Cho to speak. Chairman, I'd like to respond to what Dr. Elizabeth Quad on the claim that the judges are not to be trusted. It's not that the Democrats do not trust the judges or the judicial system. According to a recent Reuters report, 3 experienced former judges expressed their deep concerns. So such view comes from the judges themselves, but they are not able to speak out openly under the system, and they have deep concerns. That's why they have spoken to a reputable news agency. The Bar Association and the former chairman of the Bar Association issued a statement. These are experienced lawyers. They used to be deputy judges, and they could be appointed high court judges if they so wished. And they indicated that they are being thrusted into the limelight under the arrangement. You are asking the judges to play the role of gatekeeper, but they do not enjoy the relevant powers. At around year 2000, the UK courts were empowered such that if a person is to be surrendered to another jurisdiction, if there is no right of fair trial or human rights safeguards, the courts would enjoy additional privileges. In recent times, there were cases in which extradition requests were rejected due to racial cleansing. There was a case in Rwanda. A former leader fled to the UK. He committed a crime of Rwanda of racial cleansing. He killed thousands or tens of thousands of people. So there were a few cases in which the surrender request was rejected by the UK because they did not trust that there could be a fair trial in Rwanda. So the EU, the 28 EU nations were concerned because they believe that the right of a fair trial is even more important than the possible crime of racial cleansing. I believe Mr. Chang and his team would be aware of the situation. If we empower our courts with the right of refusal, what could possibly be wrong, or how could the suspects' rights be jeopardized? Law officer, thank you for the question. We totally appreciate the concerns of members due to differences in the two systems. So in terms of judicial mutual legal assistance between the two systems, this stems from Article 95 of the Basic Law. So the SAR must conduct relations with other judicial organs in accordance with the law. So for the rights empowered upon the UK courts, would that be against Article 95? The answer is no.
Well, under the law, as the Bureau explained, they adopt the minimalist approach. The crux of the matter, I'm sure Mr. To would also agree that if a case-based rendition arrangement is made, will there be any erosion of the safeguards or the human rights? Well, we'd like to have more protection. In the UK, they have this a system. Now, you said we cannot be in breach of Article 95 of the Basic Law. I don't really want to make life difficult for you. Perhaps the Bureau can explain in terms of policy. Do you think that there should be more protection for the fugitives in such a way that people will have their mind at ease? Is it a good thing, Secretary? From the policy point of view, there are two things here. Our policy objective is not so much to revamp the entire extradition arrangement. If we have to carry out such a comprehensive exercise, it would be a massive undertaking. Well, that would represent a major change for the people of Hong Kong, and this is a massive change. Well, if you are not happy, you can put your question again later on, Secretary. The existing legislative regime, the scrutiny regime, and also the safeguards and so on, and the reference to the overseas presidents, they remain unchanged. We are removing the geographical restriction, and the chief executive will be the trigger. All the safeguards, all the protection, including the reference to the overseas presidents, all these remain unchanged. Now, sometime after the implementation of the ordinance or the amendment ordinance, if there is a request for a review, that's another matter altogether. We've heard so much, and we are enhancing the safeguards. The existing safeguards remain unchanged. The legislative regime, the system remains unchanged. The reference to overseas president remain there. The long-term extradition agreement is there, and on top of that, on an ad hoc basis, on a case-by-case basis, we are providing these safeguards. Like law officer said, not only did we not undermine the human rights, we have additional elements added to it. Mr. Andrew Wan and Ms. Alice Mack. How long do I have? 4 minutes. Earlier, the Secretary said, I'd like to follow up on this, although this has been asked before. The Secretary mentioned the special surrender arrangement. The requesting party has to guarantee that the crime is within the retrospective period. I don't think the Secretary has answered the question at all. Under Article 88 of the criminal law, there are certain exemptions. However, if a person escapes from investigation or trial, or if the Supreme People's Court has already entertained the case and the people escape from investigation, then there will be no limitation on the period for prosecution. Now, has the administration discussed with the mainland regarding Article 88 of the criminal law of the PRC? Now, who has the right to interpret the limitation period? Second, even for Article 87, clause number 4, the Secretary keeps referring to this regarding the limitation period, and he's trying to set our mind at ease. Now here, the time limit for pressing charges would be 20 years for offences punishable by life imprisonment. But if after 20 years it is considered necessary to prosecute, it shall be submitted to the Supreme People's Court of Proctorate for examination and approval. The business sector is very concerned about it, and what happened in the past might catch up with them in the mainland. Corruption cases involving $1 million will be subject to death penalty unless you have someone backing you. So will the Secretary tell us whether this limitation period has been discussed with the mainland, who has the power to interpret the limitation period? And I'm sure that what Mr. To asked should be elucidated. Secretary, when Mr. Wen seems to be really mistrustful of the criminal law in the PRC, and he is asking me to look into this, and I think he's being pragmatic. Well, I don't have any faith in this criminal law, but you haven't quite answered my question. That the law is sufficiently clear. Of course, it would be up to the relevant jurisdiction to interpret the relevant law. I'm no expert in mainland legislation, but I'm just telling members that this is what the criminal law provides for. Under Article 87, there is a time limit for pressing charges. Now, under common law, the retrospectivity may not be the same in its interpretation. Under the common law, the retrospective period is that as long as the act that was committed was unlawful at the time, it would be an offense. Well, the Secretary is evading the question. I think he is interpreting the limitation period once again. Well, Secretary, please. Well, my legal advisor is advising me that under the criminal law, they are talking about the limitation period, whereas in Hong Kong, we are talking about the retrospectivity. That is whether the act committed at the time is against the law. If the act committed at the time was not an offense, then there will be no retrospective effect. That's something I was reminded of by my legal expert. Article 87 of the criminal law, the time limit for pressing charges would be 5 years for offences punishable by a fixed term imprisonment of no less 5 years. And it can be submitted to the Supreme People's Proctorate. Now, this is the supreme central body. Of course, we have to act in accordance with the law, and under the criminal procedure ordinance, it provides that all these proceedings will have to be done in accordance with the law. It's not for us to interpret the criminal law in the mainland. For this reason, we have to ask the requesting party, not necessarily the mainland. We haven't got any long-term agreement with Japan. In Japan, if they make a request, they have to give the pledge that, let's say, there is a drug trafficking case, and we have to make sure that in their judicial system there is a limitation period. There should be a pledge that should be given. We have 100 or so different criminal codes in 100 or so different jurisdictions. the courts in Hong Kong would determine under our system whether the safeguards regarding human rights and so on would be there. When it comes to the surrender of fugitives, we have all the safeguards for human rights. Well, has this been discussed? This question remains unanswered. Yes or no? It's a simple question, isn't it? It is beyond 11 a.m. I haven't received any motions, so I'm not going to entertain any more motions. The legal advisor has identified the Chen Chong-kwai case referred to by the Deputy Law Officer. This has been tabled before members. Secretary, will you repeat your question? My question is, have you talked with the mainland authorities? So the protection is not there. 87, 88 of the criminal law, there are so many exemptions, and he doesn't have the right to determine. And what guarantee, what assurance can he give? Secretary, well, we're asking the requesting party to give the pledges. This is clear. For the second round, I have Ms. Alice back, and then Mr. Paul Jay for the third round. And members keep saying the Hong Kong people are very concerned and worried. I said before, and I say again, that I met Mrs. Zheng, and she's saying that she should not be saying or summarizing what Hong Kong people feel. And Mrs. Zheng is a Hong Kong person herself. And indeed, there are some Hong Kong people who feel a certain way, and there are other Hong Kong people who feel another way. And you cannot represent all Hong Kong people. It's just like the alumni of the schools. They cannot represent all the alumni. Coming back to the ordinance, in the bill, under 2, there is 2A, 2 capital A. Now we have number 2 in 23. Now we have 2 capital A there. What is the purpose of having the 2 capital A? In the community, there are some infographics that are shown. They are saying that as long as prima facie evidence is there, it will be approved. And they are trying to spread these horrific scenario. Will the Secretary please elucidate on this, that they are trying to scaremonger, they are instilling fear in a lot of people in Hong Kong? Secretary, well, will you be more specific? What they are saying, that as long as prima facie evidence is there, it would be approved. It would be hard for the court to play the gatekeeping role. Secretary, well, to put it simply, for legal explanation, I defer to my colleague. Basically, if in the case of a jury, if the jury were to rule that someone is guilty, then someone is guilty. So we have, in the situation of extradition, the standard of proof is that if the case is referred to the jury, guided by the judge, the jury would find the suspect guilty. That's the standard of proof. Ms. Mack, so it's not as superficial as that. So it's not at a superficial level. Secretary, I think you ought to come up with some infographics to address these particular issues as well. Well, the translation might have made a difference. The standard of proof is pretty high. That this is the highest standard of proof. In some cases, they work on the basis of the arrest order handed down by the court, and in other situations, they have other standards, but the highest possible standard is the prima facie evidence. But this prima facie evidence is not as superficial as referred to by Ms. Ellisback. Perhaps my colleague, Deputy Law Officer, can supplement. Ms. Mack raised two issues. The first one is Section 23. We propose that 2A be added. The second issue is prima facie evidence. I'd like to take this opportunity to explain a little bit more. In terms of extradition of fugitives, we asked the requesting party to come up with the case under oath and explain to us the details of the case. The court will have to make sure ascertain the evidence that are produced by the requesting party. So on Section 23, two provides that if the document is derived from the requesting jurisdiction, if they are properly stamped, then we can ascertain that this comes from the requesting party. Now, 2A says that any supporting document is deemed to be duly authenticated if it purports to be signed, certified, sealed in a way provided by the prescribed arrangements concerned. That we're talking with different jurisdictions. They may have a different way of authentication. This additional provision is to allow more flexibility. In New Zealand, Section 78 1B of the Extradition Act, it provides for certain flexibility in this regard. In the UN Model Treaty, there is also a clause that encourages the requesting and requested parties to obviate the formality in order to expedite the extradition process. So over the past 20-odd years, we have received requests, and normally their law officers, the Foreign Ministry, the Ministry of Interiors, and the prosecutor, the proctorate have been involved. Basically, the cooperation is between government and government. So it is the government representatives that would authenticate the documentation in their requests. But this doesn't detract from the requirement of prima facie evidence. This is Section 10(6)(b)(3), and this is specifically provided that nothing has been changed in this regard. The standard of proof has not been changed. We are making the admissibility of evidence simpler.
As for prima facie evidence, the requesting party cannot just use an allegation to ask for extradition. They have to gather, or they have to find all the witnesses, and they have to collect the relevant statements to support their request. The Latin for building is prima facie, but it's not superficial. We need evidence to do this. That is, if a jury, under the guidance of the judge, if they accept such evidence, they would convict the person. That means the evidence can already prove the offense. But in Hong Kong, we are not trying the person and we are not integrating the person, so it's not beyond doubt. But the evidence is enough to prove the offense. Mr. Michael Tan is back. Mr. Tan, do you want to ask your third round questions? 4 minutes. Last time I asked the government this. If you want to enhance the safeguards, that is when the court is the gatekeeper. Well, because it's rumored that the judges may be under pressure. Now the threshold is raised to 7 years. And if person stand trial in a high court, then there is a jury. So can you introduce the jury into this bill? Because then we will have more gatekeepers. Well, some judges are rumored that they would definitely convict the suspects. So if such a judge is to preside over a committal hearing, what will happen? So if there is a jury, no matter what, it would give people a more positive impression. Last time, the DOJ said that when it comes to the surrender arrangements, there has been no precedent like this. So we would have to consider whether other jurisdiction would accept this. So it doesn't mean that it's not feasible. But if we do it, nobody would be interested in having case-based surrender arrangements with us. But if this is something we want, then we should be firm. We should talk to the countries one by one. If you are willing, we can have a case-based surrender arrangement. If you are afraid other countries are reluctant to do that, I don't understand this. Now you're talking about the Taiwan homicide case. It seems that the Taiwan side doesn't really want to do it, but the government told us that, well, no matter what, we just do whatever we think is right first. So why don't you consider introducing the jury into this system? Maybe a lot of countries are willing to do it. For those who are not willing, then just let them go, because this is bilateral. Now, if I want them to extradite Hong Kong people back to Hong Kong, they can also have the same requirements because it's bilateral. So, Secretary, you do not know whether the other party is willing or not, but that's the same case with Taiwan. So would you consider this? Thank you, Mr. Chen. I understand that Mr. Chen is very serious about this issue, and he has considered a lot of elements so that we can do a better job. So I would like to thank him for his endeavor. For the legislative intent, please allow me to repeat, because this question has been asked many times. We are not changing the whole SFO system. We just hope to do two things. First, removing the geographical restrictions, and the activation will be done by the CE, by an authority to proceed. So we are giving the key to the CE to start the car, but we stick to our legal system. So which level of court should be handling committal hearing? Now we are doing this in magistracy. Some people think that maybe it should be raised to district courts, and Mr. Tian hopes that it can be raised to the court of first instance, the High Court. But this is a major change. If we are going to do such a major change or make such a major change, of course, first we have to consult the judiciary because it will be affected significantly. So this is not our policy intent. I hope Mr. Chen can understand this. Now, if this system has been operating for a number of years, and if our concerns do not happen, then we'll just let it run. But if there are indeed problems and a comprehensive review is needed, then we can consider that. So I hope you would allow me to explain. I hope that within our system, with the minimum changes, we can achieve our goals. In the past 22 years, yes, this system has been operating smoothly. Now, 20 countries have signed agreements with us. Not all of them are state parties to IPPCR. However, it has been operating safely, and human rights have been safeguarded. And the fugitive can make an appeal to the CFA, and they can take reference from case laws overseas. So different legal systems will allow this. The premise is that we cannot compromise human rights safeguards. Yes, I've heard your answer. You are saying that we should start doing this first, and if there are problems in the future, then maybe a review can be conducted. Well, I want to tell you this very sincerely. For the first Hong Kong person to be surrendered, if that's a person to be surrendered to the mainland, I'm sure there will be a lot of repercussions in our society. I don't think people will say that, yes, let us send him to the mainland as soon as possible. I don't know who the first one will be. You know what the atmosphere of Hong Kong is like now. I understand that, and I sympathize that the courts will be under pressure, and you won't know about that. The judges won't be crying in front of you. And some people may say that those involved in the occupation movements, their sentence is too light. So I want to tell you that in the future there is doomed to be disputes. I remember Judge Jeffrey Ma did say that, well, the law is to ensure fair trials. That I understand that, Mr. Chen, you have your own views, but in Hong Kong, we all respect our judges and we have confidence in them. And appeals can be made to the CFA where there are foreign judges, and they will be hearing the case. At the same time, they are all reputed judges in common law. So we have a time-honored legal system. You have never answered my question. Why do you have to consider whether the other jurisdictions are willing to do this? Well, Mr. Tian, please wait for your turn again. Why do you have to consider the will of other jurisdictions? Mr. John Lee says that he doesn't hope that the present system will be changed significantly. Unfortunately, it seems that Carrie Lam thinks that she's the only one that's right. The rest of the world is wrong. At the council meeting, I asked a question. That is, now you are adding this case-based surrender arrangement. Would it affect the existing long-term agreements with other jurisdictions? The secretary said no. However, in the past few months, things have been changing in the international arena. At the end of March, EU calls on the government to lengthen the consultation period. You didn't do that. And then you submitted the bill to the LegCo immediately. And Carrie Lam said that the Democrats are colluding with overseas forces, which is an unreasonable allegation. And then EU openly issued a diplomatic note. It said that it's very dissatisfied. Carrie Lam said that it's just a declaration of their stance. She can't see the reasons behind that. So I want to ask you this. You and Theresa Chang, from March till now, you have never asked the DOJ to assess the risk, to review the amendments. Would this end the agreements with the 20-odd countries? If you haven't done that, how can you say that this won't affect the extradition agreement with other countries? In the bill, it states very clearly. Now, for those with long-term agreements, it's impossible for them to have case-based surrender arrangements with them. That is, for the 20 countries, we won't have case-based surrender arrangements with them. But for, how about the 21st country that will have a long-term agreement with us? So then we will just adhere to that agreement, and there will be no case-based surrender. So basing on this, for those who have entered into agreements with us, just that is for those 20 countries, nothing will change. We respect the views of different people, and we hope that through communications we can explain more. Let us look at the figures. For MLA, both parties would benefit. That is to combat crimes. In the past years, that is since the handover up to 31st of October last year, under the bilateral agreements for that 22 jurisdictions, we have extradited 104 people. And for Hong Kong, we have get 67 people back. So we are all trying to combat serious crimes. We are trying to help each other mutually. We have talked to the Consul General of EU in Hong Kong at a very early stage. After submitting the proposal to LegCo, I explained to them in person about the bill. And then there was another arrangement. The CE also met with some of the representatives. For the 20 countries that have entered into agreement with us, some of the consul generals have contacted me, and I explained to them that these long-term agreements will not be affected. Of course, we need to explain more. We will work hard on that, and we will continue to listen to views. And that's why we are making certain amendments. For example, 3 years is now changed to 7 years. We are only handling the most heinous cases. And we've listened to Mr. Albert Chan Hong Yi. This has helped us improve the system. We can strike a balance with human rights safeguards. So I hope that you can understand this is what we are doing. Well, I am talking about international relations, but the CE, after talking to the EU, she said that it's just a declaration. They are just making a declaration of their position, and she cannot see the justification. You are charging forward, but the other countries are very worried. Their senators, their parliament members are making a lot of remarks against this. So this would, in fact, affect your bilateral relationships with them. Secretary, well, we are now under control of the Taiwan homicide case because there is a deadline. Mr. Kenneth Leung. Secretary, you say that you hope the present arrangements can be maintained as much as possible. Now, for the SFO arrangements, I think the electrical has a function to play because all these cases would have to go through electrical through negative vetting. I have a suggestion. I don't know if you think this is totally infeasible. Now, for case-based surrender, can you also add electrical which can veto the decision? Now, for example, within 3 to 5 days after the CE makes its decision, then electrical can have a closed-door meeting reviewing the case. Some academics have suggested it, and Secretary, you say that you would consider the views of academics, but have you looked at this suggestion? Do you think it is feasible? Secretary, we have taken reference from different countries' practices. When it comes to case-based surrender, the decisions made by the executive and is activated by the executive, and then things are done in accordance with the system and precedents. If our law is not certain, and if a person is arrested, then we really need the laws to be certain. Otherwise, it's very dangerous. We have also looked at other countries' practices, and we haven't seen a similar way of doing it. Now, we have looked at the UK and Australia's approaches. They are both common law countries. They have been operating this system for a long time. I don't see any major problems. Just now, you talked about some common law countries. For the UK's Extradition Act 2003, Section 21, it states that human rights should be safeguarded. Of course, it's referring to its own country's Human Rights Act 1998. So why can't our bills of rights be included in this case-based surrender arrangements? The Secretary said that human rights will be safeguarded. So why can't our bills of rights principles be included in the arrangements? This question has been repeated many times. Yes, I've heard that question many times, but I still ask the law officer to answer the question. Thank you, Mr. Leung. Well, for the policy intent of this amendment, we are trying to minimize the changes because we have to handle the problem in our face. I have stressed that when it comes to MLA with the mainland, Article 95 has some very clear specifications. That is, things have to be done in accordance with the law, and we have to follow Chapter 3 of the Basic Law. That's about human rights safeguard, and also it includes FOO and Bills of Rights Ordinance. So against such a background, I believe that's why the government has decided not to adopt Mr. Leung's
Mr. Paul Chair, there are ways to enhance the arrangement, but I believe there is an urgency to deal with this issue. What Michael Tian and Kent Leung said is against the global trend, which is to streamline the procedures as much as possible. According to a UN resolution, in October 1997, according to 2B, there should be a regular review, and provision C asks for provision or streamlining of the procedures, and also streamlining barriers due to documentation, etc. And like the government said, there should not be a list of offenses, and all these are part of the global trend. These should be conducted in a timely manner and in line with international practice. There's a lot I want to go through. I'd like to thank the 2 law officers. They have showcased their professionalism. The law officer offered a very clear answer to Mr. Frankie Yick's question. So the answers should be illustrated in a simple and easy to understand manner, especially to the public. As for questions from members or professionals, law officer gave some very good answers. Well, Mr. Dennis Kwok is laughing right now. His article published on the commercial daily on the 29th of May was extremely misleading. He said the courts cannot play the role of gatekeeper. It's clear that for all judicial reviews or applications for habeas corpus, the courts would consider different factors. It is not that safeguards can only be completed if everything's written down. Even we have no statute law on murder. It's part of the common law system. So long as the courts consider the principles of specific cases as well as WUP on whether there's unfair justice or oppression, all these must be considered. So there are plenty of safeguards in the system. We do not need to make everything explicit. This is not in line with international trends and practice. So going forward, we might consider whether we would learn from the UK, but now is not the time. So the government should clarify all these. In terms of the what Chao Kang said from the Civic Party, well, he used political terms, and Donald Trump also said something which is more famous or influential, and he said for extradition of Wang Wanzhou, there could be negotiations. Of course, you might choose not to trust the United States. There's a lot we can learn from the United States, which is well justified. But they do have a parallel system. Then no trial is needed. The courts that do not have to be convinced, and now Obama's system is going to be reversed. And the goal is to be able to do or conduct extraordinary rendition that are not subject to the scrutiny of the courts. This is what the United States is doing. So hopefully you can explain the issue in a simple manner to the public, and also issue or offer a specific response to professionals. Mr. Dennis Kwok's column was extremely misleading. Secretary. And from what Mr. Paul said, I truly believe that different people would adopt multiple standards, and some people would hold complete belief in certain issues and complete mistrust in others. So I think the key is to be objective. So we are talking about additional safeguards rather than the removal of safeguards. So we should be pragmatic. I also agree with Mr. Chair that if we are to have a complete review of the entire surrender system, including the judicial backdrop, trial proceedings, and experience from other jurisdictions, this is a very large exercise that is not part of the policy objective of this amendment exercise. I agree that when time is ripe, this can be conducted, but this would certainly be a major reform. To deal with the two issues we have on hand, that is the Taiwan homicide and the plugging of current loopholes, so that we can have a viable surrender mechanism. We have sought to make minimum changes to the current system while retaining the strengths and advantages of the current system. So this would form the basis of discussions. This morning, the Deputy Law Officer offered a very clear account of the surrender procedures in response to Mr. Frankie Yik. So can the government consider compiling a simple diagram or information pack on the surrender procedures? Dr. Helena Wong. At any point in time, was there any surrender made between Macau and Hong Kong? Secretary, well, please speak to me instead of the Secretary indirect. Secretary, were you referring to Macau? Yes, between Macau and Hong Kong. Apparently, you mentioned this in an earlier meeting, but I wonder whether there was any actual surrender of fugitive offenders and what were the details. The answer is 0. Like I said, our current law does not apply to the mainland, Macau, and Taiwan, so there was no case of previous surrender. Yes, the answer is 0. Many people are worried about the retrospective period if the bill is passed. You have not moved any amendments to stipulate a certain period for under the Crimes Ordinance of Hong Kong. Very often we have a time bar of 1 or 2 years, after which the government would not take any action. So for the FOO, would there be no retrospective period apart from according to Article 88 of the Criminal Law of the PRC? After a case is open, there is no time bar with regards to prosecutions, and would this have a bearing on Hong Kong? In the FOO of Hong Kong, Hong Kong is a common law jurisdiction. So long as an act violates the laws of Hong Kong and is classified by as a serious offense, for case-based arrangement, we are talking about offenses that carry a maximum sentence of at least 7 years, of up to 7 years. So long as the act is conducted in Hong Kong, it would be dealt with in Hong Kong. But in civil law jurisdictions, there are provisions that if the maximum sentence exceeds a certain period, let's say if the maximum sanction of a crime is within 5 years, then the prosecution time bar would be 5 years. I'm referring to mainland China. You don't need to talk about other jurisdictions. In Article 87 of the Criminal Law of the PRC, there is a time bar on prosecution, and no action would be taken after a specific period. 5 years when the maximum punishment prescribed is fixed term imprisonment of less than 5 years, to 10 years when the maximum punishment prescribed is fixed term imprisonment of not less than 5 years but less than 10 years, 15 years when the maximum punishment prescribed is fixed term imprisonment of no less than 10 years. This is described under Article 87. Well, I asked about Article 88 but not 87. Well, I am going to talk about that. And Article 88 says there will be no limitation on the period of prosecution for a criminal who escapes from investigation. As to how this is interpreted or applied in the mainland, it is not our job to interpret the laws of the PRC for them. Our job is to require the requesting party to determine whether the relevant offense is present in their laws and whether the time bar has passed. Article 66 says that for for cases at the People's Courts or other authorities, there would not be any time bar. So for acts conducted 10 or 20 years ago, you can be prosecuted. So if mainlanders or Hong Kong people are extradited to the mainland, they can be prosecuted for acts conducted a long time ago. So does it mean that these people would have to be concerned for the rest of their lives? So apparently Dr. Wong acknowledges the importance of ruling the country by law. So the local jurisdiction would be responsible for interpreting the local laws. It's not possible for us to understand all the laws in the world. Each jurisdiction has their own laws and regulations. So we are asking the requesting party to guarantee that whether the whether the prosecution is still within the time limit. So it depends on the applicable laws. Mr. Gary Fan, please lower your signboard because I cannot see Mr. Nan Squat. This morning, the Secretary talked about UN requirements in the 1950 Milan Convention against crime. There was a resolution on judicial independence which required all party states to exercise judicial independence. That was a resolution from the 1985 Milan Convention. Do you think there is judicial independence in the mainland, Secretary? Thank you. In the surrender of fugitive offenders mechanism, well, the practice is to surrender the relevant offenders to the requesting party. the question is there judicial independence in the PRC? I would read out some of the provisions, since some of the members are interested in the mainland laws. Well, according to the criminal law of the PRC, this is the Criminal Procedure Law, Article 5. The People's Courts would independently exercise the judicial right according to the law, and they are not affected or interfered with by the individuals or the executive. So do you think the answer is yes? He answered the question. Well, I know those provisions. Do you think there is judicial independence in the mainland? I think I have answered Mr. Kwok's question. I'm not asking you to read out Article 5 of that law. Chairman, I'm not asking him to read out the article. Well, I'm asking the question for the fourth time. Do you think there is judicial independence in the mainland? I do not want to go into a debate with him. Well, my view is in accordance with the law. So do you think there is judicial independence in the mainland? Like I said, well, yes or no, Secretary, Mr. Dennis Kwok. If you do not like the official's reply, that is another issue. I'm asking for the fifth time. Do you think there is judicial independence in the mainland? There's no need to read out the provisions. I am a Hong Kong official. On any jurisdiction outside of Hong Kong, well, they have their own judicial system when dealing with the relevant judicial problems. If you ask about Hong Kong's legal system, of course, I will tell you the Hong Kong situation. The mainland legal provisions have stated it clearly. If you choose not to believe it, the People's Courts would exercise an independent right of adjudication free from interference. So you can simply say yes. You can say, I think there is judicial independence in the mainland. This is an objective statement. Why are you dodging the question? This is a straightforward question. I'm asking it for the seventh time. From your point of view, is there judicial independence in the mainland? Yes or no? Like I have said, well, you repeatedly dodged the question. I'm asking for the eighth and final time. Is there judicial independence in the mainland? Secretary, the mainland courts would adjudicate the cases in accordance with the law. As an official of the HKSAR, I can only interpret the laws of Hong Kong and what I can see from open documents. If members have their own views, if they can form their own opinion. I have answered the question many times already. I would not be able to allow you to follow up on the same question. Mr. Leung Chi-chang. I wonder whether other members have asked the question I now want to ask. Mr. Kwok was forcing the Secretary to say yes or no. I think it was unfair. As an official of the HKSAR government, he cannot express his personal opinion. I believe, well, our country's judicial system is different. We exercise common law while the mainland exercise civil law. There were negative reports in the past which led to a lack of trust by the people of Hong Kong, and this is also a reality.
So with the amendment to the FOO, people are concerned that something untoward might happen to the fugitives being delivered to the mainland. Mr. Paul J is very knowledgeable about this, and he's saying that the courts in Hong Kong, in fact, do play a gatekeeping role. I heard from the Deputy Law Officer, Mrs. Lam, or Miss Linda Lam, who has already explained this. Now, we have had the extradition agreements for 20-odd years, and we have been following these procedures. If the fugitives is sought by requesting jurisdiction, the court would play the gatekeeping role. They would look at the evidence and so on. And members are saying that the system is not good enough, and on the other side, why do we need to enter into an agreement with them? So I think members are imposing their political views, and this is grossly unfair. Some people, some lawyers or barristers, or some who purport to be judges, they say that that they are smearing this amendment bill, and they're saying that the people are sent to the mainland. I think fear stems from ignorance. Are the people of Hong Kong really ignorant and stupid? I think these people, these professional people with a legal background, are spreading this misinformation, and I hope that Ms. Linda Lam may tell us again whether the Hong Kong courts do have the ability to play the gatekeeping role. Mr. Eddie Chu, he can use his time the way he sees fit. Deputy Law Officer, right, let me take members through the procedure again. If there is a request made, then the DOJ will scrutinize all the evidence to make sure that there is enough evidence, and the restrictions under Section 5 will not apply, and thereafter this will be referred to the Chief Executive. A certificate will be issued for the court to look at the details. The court would be vetting the whole thing once again, although it has been vetted by DOJ. And all the materials will be referred to the court, and all the evidence, the witnesses, and so on. If after vetting the materials, if Section 5, the restrictions like all these political reason, religious reason do not exist, and if there is no alibi and so on, I mean, all these can be produced in court. The court would listen to the representation of the requesting party and the fugitive. Then the court will exercise its judgment. If there is enough evidence, and if the restrictions do not apply, then the court would let the executive authorities know that this can be handled under the extradition arrangement. The case can go all the way to the CFA. I mentioned the Hong Kong case. The fugitive objected to the evidence. And there are cases in which the fugitive would raise opposition. In the Hong Kong case, the special thing is the case ended up in the CFA. The proceedings went on for 4 years. And as a next step, the CE would take the decision. The court would be of the opinion that the fugitive can be surrendered, and the CE will take the decision regarding the surrender will take place. Section 5 and Section 15 provide for the restrictions. The fugitive can make representation that the restrictions will apply to him. Or under the Hong Kong law, there are other safeguards that will apply, and he can ask the chief executive not to issue the surrender order. If the surrender order is issued, then the fugitive can file for judicial review, and the court will then decide, will judge whether the decision is rightly made, or whether the safeguards have been given, whether there was any wrong, unjust, or oppressive decision being made. Mr. Chairman, the FATF is looking at money laundering and anti-terrorism issues in the world. Now, these FATF, in 2018, there was a report page 202 criticized that Hong Kong hasn't got any arrangement, extradition arrangement or MLA arrangement between Hong Kong, mainland and Macau, and Hong Kong has been relegated to a lower position in the international ranking. Canada, Australia, Malaysia, the UK and New Zealand were ranked in the exercise in the latest 2018 ranking. I'm sure that the Security Bureau and the police must have received the draft. Once again, they severely criticized the absence of an extradition or rendition agreement between Hong Kong and the mainland. This is getting in the way of money laundering and anti-terrorism initiatives. That would make a difference to whether Hong Kong is a safe city, whether Hong Kong is a good business environment. There are some Western countries that express concerns about this amendment exercise. Now, my question for the Secretary is this: are they concerned about the passage of the bill, or are they concerned about the time taken for the passage of the bill? Secretary. Thank you very much, Ms. Ng, for raising this point of view. Now, this FATF did criticize Hong Kong for the absence of an MLA and rendition arrangement with the mainland. Indeed, this would be detrimental to the efforts to combat anti-terrorism and also the financing of the terrorists. And they urge us to get on with the arrangement. And I think we have to make sure that in our system we will have the MLA and rendition arrangement between Hong Kong, mainland and Macau for us to combat anti-terrorism or terrorism and also the terrorism financing. There are some comments made, and after our elucidation, some people do understand that we haven't changed the entire system. We're just trying to make the system that much more effective, and as a supplementary measure, we can deal with the matters on a case-by-case ad hoc basis. There are other suggestions that we should spend more time on communication, that we understand. But as we said repeatedly, we have to deal with the Taiwan case, and we have to plug the loopholes. Our timetable is very much dictated by the Taiwan homicide case, because the suspect is expected to be released sometime in October. Like Mr. Ng said, we have a gap in our legislation in relation to Taiwan Macau and the mainland. With this gap, we will not be able to deal with the case, and we hope that before the release, we will be able to get something done. I'm grateful to Mr. Ng. I'm sure that with this arrangement, the FATAC would have regard to this. With the passage of the bill, I'm sure that we will be measuring up to the requirement of the FATF. Mr. Ng, are you saying, Mr. Secretary, that the homicide case in Taiwan is one of the reasons to amend the law? I think to avoid Hong Kong becoming the haven for money laundering, for Hong Kong to become an anti-terrorism base, the amendment would certainly do a lot to help in this regard. Yes, that's correct. Mr. Jeffrey Lam, second round. Chairman, I noticed that Hong Kong has entered into agreement with 20-odd jurisdictions, and there are different ways, like with Singapore, we have homicide and manslaughter. In Singapore, we have the two separated, manslaughter and homicide are two separate offenses. I've taken up all the matters with the Secretary, like offense 15. This covers bribery, corruption, secret commission, and breach of trust. All these four items are different things altogether. Are we going to separate them out? In particular, the breach of trust, this can be really serious. If you entrust someone to do something, it is a kind of trust. So I hope the Secretary would elucidate a little bit more here. Also, if a request is made by a jurisdiction, is there any time frame? Now, of course, the Chief Executive would trigger the whole thing, and the matter will end up in the court. The court is pretty busy. If it takes 1 month or 2 months, and the matter is still unresolved, it will not be fair to the fugitive sought. Now, when a request comes through, is there any restriction on the exit of the fugitive from Hong Kong? Secretary, thanks very much for the question. Of the 37 offenses, one of them has to do with the bribery, and there is a reference to different types of offenses. Now, we have to bear in mind that we are fulfilling the international obligation regarding bribery. So one of the reasons of keeping these offenses is to ensure that we can live up to the international obligation. Now, for trust, perhaps I can call upon Mr. Ho, the Deputy DPP, to brief members on this. Mr. Paul Ho, item 15 covers bribery, corruption, secret commissions, and breach of trust. Breach of trust refers to an employee or an agent they are in breach of the trust of the principal and solicit advantages to deal with the issues of the principal. Now, for corruption, it would involve the receipt of secret commission and act in breach of the trust of the employers and the principals. I can cite some examples for members. What is the meaning of principal, the relationship between the principal and the agent. It's like the relationship between the employer and the employer, and the boss and subordinate, principal and agent, the directors of a company, and so on. Now, for these acts of corruption, there must be an intent to defraud, so people will not be inadvertently caught by this. What about the immigration control and the time frame for scrutiny? Yes, Deputy Law Officer. Under the FOO, when someone is arrested, unless he can prove exceptional circumstances, the person will be taken into custody. The DOJ is aware that a person should not be detained in an unreasonable manner, so we would require a formal request, and all the requests and all the evidence has to be there before the process would be activated. And the court is also aware that someone will be detained, and in these kind of cases, the court would accord a high priority to these cases because of the detention. What about immigration control? Once someone is taken into custody, they will be detained, and there will not be any problem with the immigration problem. The court would be aware of the detention of the suspect. There will be high priority accorded. Mr. Ray Chen, I hope that the people of Hong Kong would see what Mr. Dennis Kwok did. He pushed John Lee about whether there is any judicial independence in China. We are asking John Lee, representing the Hong Kong government, we ask him whether he sees any judicial independence in China. Now you can say it's irrelevant. You can say it's got nothing to do with the bill. I mean, it's no good for you to just read out word for word from the law of the PRC. There are many questions that the Secretary should answer direct. Maybe by direct answering the question, he may give rise to more problems. Now, the retrospectivity, many members ask a lot of questions. Under the criminal law, Article 88, if someone escapes investigation, then there will be no limitation on the period for prosecution. Now we're talking about the fugitives, that the fugitive has fled the mainland. He's escaping from investigation. Then there will be no limitation on the period for prosecution. You can tell the people of Hong Kong as such. Why do you want to just read out word for word Article 87 of the criminal law? Now, people are asking about Taiwan. Now, you may say that I'm being repetitive. Now, if we're talking about banana, you should stick with banana. You shouldn't talk about pear and mango and so on. Now, he said that there are 187 jurisdictions. We're not asking you about Mauritius. We're asking about Taiwan. I asked you whether it is the Ministry of Justice that will be the authority. You refuse to answer the question. You have to assuage public concerns. The government keeps saying that the FOO has been serving us well, and there are enough safeguards in the law, and there is not much changed. If anything, there is added protection. Over the past 22 years, what is the difference? Over the past 22 years, you enter into agreements with the sovereigns, and you are on equal footing. But here, Hong Kong is dealing with the mainland of China. There is a relationship of subordination. And previously, if there are problems, people can take retaliatory action. But in Hong Kong, when we're dealing with the subordination to mainland, we can't even say a word. We can't even whisper a word in protest. Now, my question is about the additional safeguards. They're not written into the law. My question is, if the requesting party, I'm having China in mind, if the requesting party is in breach of the pledges in the agreement, what can the government do, or will the government take the initiative to do something?
Because the court doesn't play a role here. That is after the surrender. Unless they make another request, then the DOG can look at the track record, and if they violated anything, then they may reject the request. But would the SAR government take the initiative to do anything? Is there a mechanism to look at the progress reports? I have moved an amendment. If anyone is surrendered to the requesting jurisdiction, he cannot enjoy the rights that's listed in the arrangement, then the CE should not issue any certificates to that jurisdiction anymore. So would you look at the track record of that jurisdiction and play the role of gatekeeping, and can this be included in law? Secretary, you asked several questions. The law officer would answer the questions concerning mainland courts. Before that, I would like to say this. Now, when we communicate with Taiwan, it's always through the platforms of Mainland Affairs Council and Taiwan Affairs Office. In the past, we entered into agreements through this platform. So for FOO and the scrutiny of the whole SFO system, we have to comply with Hong Kong laws. When the CE exercise her powers, or when the SAR government exercises any power, all this have to be in line with Hong Kong laws and the basic law. So the SFO is the same. As for China's duty to implement international covenants, China has been doing that fully. You can look at some open information. And as an SAR government official, I would not comment on the judicial system on Western countries, which are so praised by certain members. So we just do our job in Hong Kong. We do not intervene in other countries' matters, because each country has its own legal system. It has its own way of doing things. So I would not criticize other countries, including all the countries in the 5 continents. I would not comment on what they do in terms of the judicial system. So I would just comment on Hong Kong's legal system, and we would assure the rights of the relevant people. And we would ensure that the time-honored system are protecting their rights. Mr. Paul Chang. After the handover in 1997, the SAR and the mainland, in accordance with Article 95, have entered into 4 MLA arrangements. The first one was in 1998. The SAR and the mainland courts have agreed to convey the relevant judicial documents. So through this 1998 agreements, now we can transfer the documents. And in 1999, we have a mutual enforcement of arbitration rulings. So for the 1999 one, it's not about cooperation among courts. Is about the enforcement of arbitration rulings. In 2008, SARG and the mainland mutually recognize each other's ruling arrangements. Now, for a contract party, if he agrees to choose Hong Kong courts or the mainland courts as the jurisdiction courts, then the courts can enforce the relevant rulings in accordance with the agreement. So this arrangement has been in place from 2028 onwards. It has been time-honored. And then in 2019, the courts of the two places have made an arrangement concerning the production of evidence. So under Article 95, there is a mechanism, and the jurisdiction are working on equal status in accordance with the law. This is the design of the basic law. And if this is not done, it's already breaching the basic law. And I completely understand this. That is, we are talking about case-based surrender arrangements, and if we are doing this with the mainland, it would be different from the previous 4 time-honored arrangements, because this is about criminal matters, MLA. So personal freedom may be affected. So when the government considers this, it tries its best to take care of the rights of the people involved, in particular if their freedom is affected. But how much can we do to be perfect? I think different people will have different views. For this amendment bill, nothing in it would jeopardize the rights of Hong Kong people under Hong Kong laws. So for the SFO arrangements, if the person involved thinks that his rights are undermined, he can raise objection to Hong Kong courts. Mr. Lok Chuk Hong. Well, for the FOO, there is a significant spirit. That is, for offenses concerning politics, religions, or race, the fugitives would not be surrendered. The oppositions are discrediting our courts. They say that we are subordinate to China. We cannot say no. I think this is a strange logic. If you look at our courts, they are very independent. And sometimes they make remarks that are not too friendly to the government. I want to stress that our courts are judicially independent. So races, religions, and political opinions cannot be used as the grounds for surrender. So you would not have a list of political offenses. But if a person is asked to be surrendered because of economic issues, but if he has a strong political belief which is not friendly to the requesting jurisdiction, for example, he always writes online comments against that jurisdiction, or he even organizes certain actions against that jurisdiction. So would that become a defense so that he would not be surrendered on the excuse of other offenses? Would this be a defense? And what would Hong Kong do? Of course, I know that you have taken a reference from other countries. Are there other examples? I think this question has also been answered. Thank you, Mr. Look, for your question. We have 4 sections under FOO to ensure that this would not happen. First, under Section 2.2, double criminality. So in Hong Kong, we have religious freedom, press freedom, and reporting freedom, etc. So this would assure his freedoms in this regard. So if it's not a criminal offense in Hong Kong and the imprisonment term won't be over 10 years, then with Section 2.2, he will not be surrendered. And about politics, we have 5 sections. So FOO attaches a lot of importance to this. That includes 5.1a. If that offense is of a political nature, no matter how it is described, it would be the request would be rejected. Then 5.1c. Well, the excuse is that he's committed another offense, but actually it's because of his political belief or his religion, etc. So for 5.1d, because of race, religion, or political opinions, and during the trial he may be prejudiced or he may be penalized or detained, that person would not be surrendered. Ms. Lam? As for FOO, as the Secretary said just now, we are mainly targeting criminal fugitives. So it's not about political offenders. So here we only have criminal offenses, no political offenses. But the law has also considered certain circumstances. That is, well, in some places, they may use criminal offense as an excuse, and actually they are prosecuting that person for political or religious reasons. So under Section 5, there are some restrictions. If the court is satisfied that the relevant prosecution, although on the surface the offense is a criminal one, but there's there are other motives, that it's that person in the course of prosecution will be prejudiced, then this is a reason for refusing the request. And for Section 12b, the committal court, when it conducts the relevant hearing, it should look at Section 5 and it should collect evidence in accordance with this. And then 12(4) further states that for the court of first instance, when it hears the application for habeas corpus, it should also look at Section 5's restrictions and collect evidence accordingly. So for the person involved, if he has a lot of views concerning the requesting jurisdiction's politics, and he believes that the request is made on the ground of this or on the ground of his religious belief or political opinions, and he will be prejudiced at trial, then he can adduce evidence and the court will make a decision accordingly. Regina Ip, last week I think you've noticed this, that there were a lot of signature signing campaigns, and there were many schools, alumni signing petitions online. It seems that millions of people in Hong Kong are very afraid. So I would like to ask the government, in the past 20 plus years, we have entered into agreement with 20 countries. How many requests have we received, and how many requests have we made? How many people have been affected in the 20-odd years? Let's talk about other countries first. Thank you for your question. For people surrendered to other places, 1 104 people under the bilateral agreements. Over the 20 years, 104 people. Yes, ever since the handover from the end of 2018, of course, there are also some others under multilateral agreements. As to which country received the most fugitives from us, number 1, USA, 68 people. Second, 10, Australia. UK 8, Canada 7, Korea 4. These are the top 5. As for the offenses involved, the most are related to drugs or drug trafficking, 38 cases, and fraud, robbery, and cheating, theft, 32 cases, murder or manslaughter, 12 cases, rape, sexual assault, 9 cases, money laundering, 13 cases. So these are serious criminal offenders. They are not ordinary people. We are under the threat of such criminals. So I hope you can understand. Now we have received a number of requests as well, involving 76 people. As for the offenses involved, they are similar. Robbery, cheating, bribery, money laundering, drug trafficking. Is money laundering included in the present list of extraditable offenses? Yes, it's included. Well, it seems that there were mainland offenders laundering money in Hong Kong, and that involved $1 billion. Yes, that can be very serious. I do not have the exact figures, but money laundering can be very serious. And also cases involving drugs may also be related to money laundering. You talked about bilateral agreements. So how about multilateral agreements? Later on, Ms. Lam will answer the question. As for multilateral agreements, because we have entered into certain international covenants, a total 14 of them. So for the 46 items of extraditable offenses, 9 items have been removed. So for the remaining 37, they are all covered under the agreements. Now there are several multilateral covenants, for example, anti-bribery covenant or a covenant against multi or cross-national crimes. So for the state parties, they can make surrender requests to Hong Kong. And in accordance with the covenants, we have made an SFO. So there was only one case. Yes. Chairman, this is the first time that we tell member about this. Well, for that 14 covenants, some of them are against racial discriminations, some of them about hijacking airplanes, endangering civil aviation, against harming diplomats, against taking hostage of people and torturing people, and also against the trafficking of psychiatric drugs, covenants against threats to marine safety, against terrorist explosion, against offering provision to terrorists.
聯合國反腐敗
UN Convention Against Corruption and Anti-Piracy and Armed Vessels Asian Convention. So these would proceed whether or not the amendment is passed. Yes, because these are multilateral agreements. Members, the time of this meeting is up. We will have the regular meeting of the panel on security tomorrow from 2:30 to 6:30. We will continue to discuss some issues in relation to the MLAO. And the case of Cheng Chong-kui was cited. I think this is a helpful case to refer to. So well, Mr. Dennis Kwok was the one who was beating around the bush, and he was misleading. I think a lot of so-called judicial officers might not have a full grasp of the situation. During the break, I have relayed your request to the law officer, and hopefully they can furnish the relevant information at tomorrow's meeting. Deputy Law Officer, we will bring a hard copy with us tomorrow. The legal advisor also shared one of the cases with you. So meetings adjourned. Thank you.